Welcome to Seacoast Real Estate Academy. Today on our License Law and Rules series, we will continue discussing agency and disclosure requirements. Agency disclosure requirement applies only to sales transactions. It requires licensees to provide prospective buyers and sellers at first substantial contact with a copy of the Working with Real Estate Agents disclosure, to review the disclosure with them and then reach an agreement regarding their agency relationship. The licensee providing the disclosure should also include his or her name and license number on the form. In the case of a prospective seller, the agent may either act as the seller's agent, which is the typical situation and requires a written agreement from the outset of their relationship, or work with the seller as a buyer's agent if the agent already represents a prospective buyer. In the case of a prospective buyer, the agent may either act as the buyer's agent under either an oral or written agreement as addressed in Rule A.0104A, or work with the buyer as a seller's agent, disclosure of which must be in writing from the outset. Disclosure of agency status by seller's agents and subagents to prospective buyers A.0104E. Paragraph E of Rule A.0104 requires the seller's agent or subagent in sales transactions to disclose his or her agency status in writing to a prospective buyer at the first substantial contact with the buyer. It is recommended that seller's agents make this required written disclosure using the form provided for this purpose in the Working with Real Estate Agents disclosure that must be provided to buyers, as well as to sellers, at first substantial contact. This form has a place for the buyer to acknowledge receipt. The disclosure may, however, also be made using a different form. The most important point is that the disclosure be made in writing in a timely manner. The purpose of the disclosure requirement is to place prospective buyers on notice that the agent they are dealing with is not their agent before the prospective buyer discloses to the agent information which the buyer would not want a seller to know, because it might compromise the buyer's bargaining position. Most frequently, first substantial contact will occur at the first face-to-face meeting with a prospective buyer. However, the point in time that first substantial contact with a prospective buyer occurs will vary depending on the situation and may or may not be at the time of the first or initial contact with a prospective buyer. Many first contacts are by telephone and do not involve discussions which reach the level that would require disclosure, although some initial phone contacts, especially those with out-of-town buyers, could reach this level. First substantial contact occurs at the point in time when a discussion with a prospective buyer begins to focus on the buyer's specific property needs and desires, or on the buyer's financial situation. Typically, that point in time is reached when the agent is ready to solicit information from the prospective buyer that is needed to identify prospective properties to show the buyer. An agent planning to work with a prospective buyer as a seller's agent or subagent should assure that disclosure of his/her agency status is made in writing to the prospective buyer prior to obtaining from the prospective buyer any personal or confidential information that the buyer would not want a seller to know. A few examples of such personal or confidential information include the maximum price a buyer is willing to pay for a property, the buyer's ability to pay more than the price offered by the buyer, or the fact a buyer has a special interest in purchasing the seller's property rather than some other similar property. The disclosure must be made prior to discussing with the prospective buyer his or her specific needs or desires regarding the purchase of a property. The best policy is to make the disclosure at the earliest possible time. If first substantial contact occurs by telephone or by means of other electronic communication where it is not practical to provide written disclosure, the agent shall immediately disclose by similar means whom he or she represents, and shall immediately, but in no event later than 3 days from the date of first substantial contact, mail or otherwise transmit a copy of the written disclosure to the buyer. Disclosure of agency status by buyer's agents to sellers or seller's agents. A.0104F. Paragraph F of Rule A.0104 requires a buyer's agent to disclose his or her agency status to a seller or seller's agent at the initial contact with the seller or seller's agent. Initial contact will typically occur when a buyer's agent telephones or otherwise contacts the listing firm to schedule a showing. The initial disclosure may be oral, but a written confirmation of the previous oral disclosure must be made, except in auction sale transactions, no later than the time of delivery of an offer to purchase. The written confirmation may be, and usually is, included in the offer to purchase. In fact, Commission Rule A.0112A19 requires that any preprinted offer to purchase and contract form used by an agent include a provision providing for confirmation of agency status by each real estate agent and firm involved in the transaction. If you like this video, feel free to share it with a friend. For more real estate education content, please subscribe to the channel. From all of us at Seacoast Real Estate Academy, thank you for watching.